always been atrocities, wars, crimes against humanity, genocide, situations where one population or group of people tried to dominate and devastate another group of people. But there's never really been a large-scale international address to it. Even after World War II, we had the beginnings of it, let's say, with the Nuremberg trials. But there's never been a really effective method of holding accountable those people who commit large-scale genocide and atrocities. Now we do have an institution which is trying to address that. It's called the International Criminal Court. Today we're going to be talking about that. Let me go right to my guest. Let me introduce you to Sean Butler. You're the co-chair of the International Criminal Court Alliance.
Right, Ken.
I got it right. Okay, great. So let's take a little bit of an interesting story here. Before we even go into what the International Criminal Court is, how come you got involved in it?
I learned about widespread atrocities when I traveled to Cambodia. I went to Cambodia in the early 90s, and one of the things that they have set up is memorials, commemorations in certain places. One of them has a tower of skulls out at the killing fields, and I thought to myself, I'm a lawyer. How come there's nothing really to deal with this situation? And then several years later, I heard about the International Criminal Court, and it won't go back to deal with things before it entered into force, but it is a system that will prospectively deal with those types of situations, and I thought that was a good idea.
So when you say deal with the situations, you don't mean to intercede and stop it like police action, but to deal with accountability.
Yeah, the International Criminal Court will only do things to prosecute people after the crimes have been committed. Until the crimes have been committed, obviously, there's no one to prosecute. But obviously, the hope with the International Criminal Court, as with most criminal laws, is that it will also have a deterrent effect. And so the fact that there is a threat of prosecution hanging above someone's head might make them think before they do the wrong thing.
Okay, so this is the concept of, by implementing consequences, will prohibit bad actions. That it acts as a restraint.
Yeah, not to prohibit, but to make people know that there are consequences. And sometimes if you have a feeling that there's no need to worry because no one will ever hold you accountable, you don't even think about those things. Now there is a system that says there's an opportunity to be held accountable for genocide, war crimes, and crimes against humanity in situations where, unless your national government acted before, there was nothing going to happen. Now, even if the national government doesn't act, there is this international institution which has a very limited jurisdiction, but still has the threat of prosecution.
So when did this start?
The treaty negotiations started in the early 1990s. The treaty was actually finalized July 17th of 1998. We recently had the 10th year anniversary, and the treaty entered into force, began operations July 1st of 2002. That's when the staffing started, the building was set up where they're going to hold the trials, and all the things that happened to make it actually a functioning court started in 2002.
So this is a really fresh, almost pubescent organization. I mean, it's only 6 years old in reality.
It's only 6 years old, and it's already going through some growing pains.
Well, that's to be expected. So just to get this clear, there was treaties amongst nations to allow for prosecution of atrocities, violation, crimes against humanity, genocide, but they had to develop two things: a protocol for holding the trials and doing the investigations, what's our operating procedures, and also some kind of code of what law, because laws vary amongst countries, and you had to come to an agreement about what can we agree upon internationally as this is an accepted code of violations.
To give a little brief historical context, 1949 was the Genocide Convention. There wasn't the word genocide until the 20th century, and so the Genocide Convention requires that if there is genocide, nations take steps to prevent it and to hold people accountable for it. That got put on hold for a long time. And so then the idea came up 50 years later to start this court. And the real impetus, I think, was the events that people saw happening in the former Yugoslavia. And so when the incidents were happening in the former Yugoslavia, there was a greater push to make a permanent court. The United Nations made 2 temporary criminal tribunals, one for the former Yugoslavia and one for Rwanda. But those were limited to the territory that those events occurred, former Yugoslavia or Rwanda. The International Criminal Court hopes to have worldwide jurisdiction. It does not at this time. It requires the consent of either the nation where the conduct occurred or a UN Security Council referral.
So in other words, most of the business, the things they address either at the request of the UN or at the request of the nation of some state that's a signer to the treaty.
There's only been one that's a UN Security Council referral, so that's a possibility. The situation in the Sudan, the Darfur situation, was a UN Security Council referral. The other cases that are currently pending before the court have come on referrals from the nation states where they're involved, the Democratic Republic of Congo, Uganda, and the Central African Republic.
Well, I'm just curious, when you say it's coming from those 3 African states, does the parliament, the legislature, the president, who makes the request? How does that occur?
Different situations in different countries. Generally, it comes from the executive branch, but it's sometimes with the prodding from the parliament, and sometimes complaints can be made by individual citizens. To be able to be effective, though, you need to have some way to operate on the ground, and so it's much better if you have the consent of the local government. And so it can come in different ways.
Okay, and again, just to finish off that other question I was asking, the actual code that people are going to be charged against, right? When you're going to charge somebody.
The elements of crimes are defined. There is a definition that sets forth in great detail the elements of each of the 3 crimes that are currently within the jurisdiction of the court. And so that was negotiated before 2002 with the parties that were working on the treaty. The United States is not a party to the treaty, but did participate in working out the elements of crimes and the rules of procedure and evidence.
And the punishment?
There is no death penalty. The maximum punishment is life in prison.
But those penalties are part of that agreement?
Correct. The penalties are set forth. There is no death penalty. Most of the international community has rejected the death penalty already. And so with this court, there will be no death penalty. They rely on different nation states to take custody to hold the people who are accused or convicted. There's been no convictions yet, so they haven't had a problem of where to put someone to hold them yet when they've been convicted, but they are holding them now in The Hague.
They're holding some suspects, let's say.
Correct.
But so in other words, if I'm in country X, I make an appeal to the ICC to address some rebel or general, rogue general, somebody who's committed a crime of genocide, crimes against humanity, and the third one is?
War crimes.
War crimes. And I have them, and the ICC accepts it, and we get the guy, and you prosecute him. You're going to send him back to me for incarceration.
Not necessarily. The parties to the treaty, there's a request that they volunteer to be able to hold people in custody. So, for example, if there was someone taken into custody with regard to the Darfur conflict, because Sudan hasn't been cooperative regarding that, it's not likely that we could hold the Sudanese authorities to ask to hold that person. Canada, however, has said they will. They will accept people to hold them in prison during whatever their prison term is.
Because they're a signatory to the treaty, so therefore they're performing an international function because of a treaty obligation.
107 countries are parties to the treaty, including all of our NATO allies except Turkey, Mexico, Canada, a whole lot of countries, all of Europe, parties to the treaty, but the U.S. is not. And that's actually a shame, because we've held ourselves out traditionally to be champions of human rights. And while this is not a specifically human rights court, these are human rights issues, these are rule of law issues, and the U.S. should be involved.
Okay, so who does that put us in association with? Is that U.S., Turkey?
China's not a party. Libya's not a party. Israel's not a party.
North Korea, I guess.
North Korea's not a party. South Korea is a party. So yes, we're not in very good company. Although the truth is, there's just over 200 countries, and so there's still about 100 countries that aren't parties. But a lot of the countries that you think of as the champions of the rule of law and the champions of human rights have signed up for this, and we haven't.
Britain, Denmark, Norway, Sweden, all of the European countries, all of the members of NATO.
Yes, except for Turkey.
And Asian countries like Japan, Taiwan, Indonesia.
Japan recently joined. Japan was not one of the early ones, but they actually joined about a year ago. And Asia has been slow. A number of countries in Asia have joined. Cambodia was one of the early countries to join, and I think it's a little ironic that the places where these things have happened in the past have been the quickest to sign on. So South Africa, one of the biggest supporters. Cambodia, one of the biggest supporters, not financially. Having Japan on board is big financial support because they're a very wealthy nation, and the funding of the International Criminal Court, because it is a voluntary association created by treaty, will come from the parties, not from other sources. And it's going to be used on a similar formula to that the United Nations uses. So the more wealthy you are, the bigger the amount of your dues are. Having Japan as a party to the treaty is a big help to the treaty.
Well, that's good.
To the court.
Now, the listeners, if anybody wants to find information about this on the internet, they can go search International Criminal Court, and they'll find several websites and other people commenting about it and so forth. International Criminal Court. Just Google that or search it. Now, my question is something you brought up. I think for myself and the general public, break it out from UN courts and International Criminal Court. This is not a functionary of the United Nations. It's not in the General Assembly or anything like that. It's separate from the UN.
That's correct, Ken.
Explain the differences and why that was done. Why isn't this in the UN?
The World Court, or the International Court of Justice, sits in The Hague. It's in the same city, but it's a different court.
And that's a UN.
It is the chief judicial organ of the United Nations and typically involves disputes between nations. And so you may have disputes that are commercial in nature where the nation takes the part of the actual party who's been involved. The International Criminal Court is different. The International Criminal Court is independent of the United Nations. It's a separate treaty-based organization, but it has a relationship agreement with the United Nations so that if the United Nations decide that there's something about peace and security under Chapter 7, they can then refer that to the International Criminal Court. But the reason the International Criminal Court wanted to be independent of the United Nations is the politics of the veto in the Security Council. The politics of the veto in the Security Council allows one of 5 countries to say something won't happen. And they didn't want to allow 5 countries to have that type of power over what the prosecutor would do. It's one of the things the U.S. pushed for when the treaty was being negotiated, because the U.S. wanted to have the power to control prosecutors' cases. But the countries of the world didn't agree. They wanted the prosecutor to be more independent. There is a provision of the treaty that allows the United Nations to defer prosecution, so that if there's a situation where the prosecutor has said, we see criminal activity that we believe is of sufficient gravity that we think we should prosecute, if the United Nations says, well, wait a second, we believe that if you don't prosecute for a period of time, maybe that will help the peace process, the United Nations has the power to, on a 1-year basis, have a deferral, but that 1 year can be renewed for as many years as they decide.
So, and I've heard those kind of comments be made about trying to stop the hostilities going on in Darfur. If you create, the concept is very simple. If you have a dictator or a belligerent, whether it's just a head of a guerrilla movement or whatever, if you put his back to the wall, then there's no telling what he's going to do. You got to give him a doorway out. You got to allow him to escape and achieve asylum in another nation, sort of like what happened with Idi Amin. It's like if you say, well, you know, as long as you get out of the country, and I think he went into exile in Saudi Arabia or somewhere, but he had a lot of atrocities in his country, but he left. And the concept is, if you're going to close the door and threaten this despot, this dictator, his actions are going to be predictably atrocious. You know, he's going to react heavily. Is that the reason? Is that the concept?
That principle is the reason, but I don't think it actually applies in the situation in Darfur. I understand the principle, and the principle is that there may be some situation where giving someone an opportunity to negotiate something will make them stop the hostilities, but that's not been the history in Sudan. In Sudan, the history has been every time you gave the government an opportunity to withdraw, they only increased the pressure. And so what's needed sometimes, instead of the carrot, is the hammer. And what we've got here is the hammer saying, no, we can't let you keep doing this any longer. You have to stop, and if you don't agree to voluntarily stop, what we're going to do is issue the indictment, and it hasn't been issued yet. There's a request for indictment. If there is an indictment, then the obligation of every country that is a party to the treaty will be that if al-Bashir goes to that country, they have to arrest him and turn him over to the court.
He's the principal. He's the suspect, or what do you call him? The person to be indicted.
He's one of the accused.
Of the accused. How many in this case in Darfur?
In Darfur, there's been 3 government officials who were named. That's not accurate. 2 government officials, 1 rebel official. And one of the things that didn't happen in America is that when the announcement of the request for the indictment of al-Bashir, the president of Sudan, came out, 3 days later, the prosecutor announced that they were also investigating the rebel group in Darfur for alleged attacks on peacekeepers. And so the point is that you're not choosing sides. You're going to take whichever side is doing something wrong, that if you're seized of the conflict, here they have the Darfur conflict, if the rebels do something wrong, they're going to be held accountable. If the government does something wrong, they're going to be held accountable, not choosing sides.
And what was this guy's name again? These names take a little while to get control of. What's
the president of Sudan is al-Bashir.
Al-Bashir.
Right.
Okay, and 2 other people. You know who they are?
I know who they are. One of them, who was with the government, has now been promoted to be the chief of the government's humanitarian affairs. The other one is a rebel, and so obviously he's not part of the government.
Okay.
I forget their names.
Well, that's fine. Okay, so now, the ICC is currently active in this situation in Darfur. That's the business that's going on now. They made a request for indictment. The indictments haven't been finalized yet, right?
The indictment of al-Bashir hasn't been finalized. I believe the 2 others already were finalized earlier.
Okay, and what other conflicts or areas of interest is the ICC operating in currently?
Currently, there's the Democratic Republic of Congo, there's Uganda, and the Central African Republic. In those cases, one of the things that's really prevalent is the use of rape as a weapon of war, so that soldiers will go into communities and gang rape women, sometimes forcing family members to watch. And the point is to drive communities apart so that when the children are born, they're ostracized, so that the women can't go back into their communities because they're ostracized, and it really is communities apart. They also use mutilation as a means to make the burden heavier on the victims, so that if it's another side that's being fought against, if you mutilate someone, you can't just bury them, you have to take care of them. Another thing that's happening in those places is use of child soldiers on a widespread basis. Children taken as slaves, and the girl children used as sex slaves, and the men children, boy children, really shouldn't say men, boy children, used as soldiers on the front lines. It's disgusting.
So the ICC has determined that it's happening there was a word, I mean, it's not just an incident of 1 or 2 people. there's a degree of
widespread and systematic.
Widespread and systematic is a terminology, okay?
That's the language for crimes against humanity. You don't have that requirement actually for war crimes. War crimes can actually occur on a single or sporadic basis. But to have a crime against humanity, it has to be pursuant to some organizational scheme, and it has to be widespread and systematic. To be genocide, you have to have an intent to attack a certain specified group. It can be based on race, religion, or some other protected category, an intent to destroy in whole or in part that protected group. And so in general, that would take a widespread conduct. You're not going to find that, even though it says in part, if it's one or two incidents that you have that intent to wipe out that group.
Okay, but now an interesting thing happens when you're talking about these three countries, and they're basically in the middle section of Africa, right?
Great Lakes region of Africa.
The Great Lakes region. It would seem that there's several warring factions in those countries, and each of the warring factions could be charged, legitimately charged, with some of these atrocities. So you're really trying to change, or you're given a task looking there at a cultural abnormality of barbarity. It's not like an isolated thing, like these are the villains, it's the government oppressing the people. These are separate military factions. Let's say there's 5, or whether there's 3 or 10, but let's say there were 5, and they're all doing these things. They're cutting off hands, they're raping women, they're using child soldiers, they're moving drugs, they're imprisoning people. They all have this barbarity going on. So how would you go in and, you can't, you have to pick like 50 people to indict.
It's true. You have to look at the most senior leaders, or those people who are most culpable. So you can either look at who's directing this, who's making it happen, and that's the primary focus. But in some cases, you can have someone who's on a lower level who's just way out of control. So conceptually, those types of people could also be brought in for the type of conduct that they're doing individually. But the point is not really to go against the lower level people. It's to stop it at the top where the leaders are involved. And that's one of the things about this court, is that instead of it being states like the United Nations, this court will try individuals. And your official capacity doesn't matter for the International Criminal Court.
Okay. So what have they issued any indictments or anything for any of those 3 African countries?
Oh yes, there are indictments issued for all of those, and in fact, I started off by saying there's growing pains. The first case that was to start before the ICC is based out of the Democratic Republic of Congo, and that's the Lubanga case. Mr. Lubanga was accused of using child soldiers on a widespread basis. One of the rules with the court is that the prosecutor is entitled to take confidential information on a condition that it will stay confidential and that it will only be released with the consent of the party who's given the information. The United Nations provided a large bunch of information regarding Mr. Lubanga that was used by the prosecutor and not disclosed to the defense. There's been an order for the release of Mr. Lubanga while the court determines what to do about the failure of the prosecutor to turn over that evidence. In America, they would call it a Brady violation, where you have to turn over exculpatory information.
Discovery, whatever, yeah.
Right, and I don't know whether or not the information is actually exculpatory, something that would show you were not guilty, but obviously it was important that the judge thought the information was important, and that the judge said, your failure to turn this over to the defense is enough that we have to decide what we're going to do. So those are some of the growing pains, how a court who has seized such a serious situation where literally thousands of children had been taken as slaves and used as slave soldiers, and you have to compete with that, the interest of the accused in a fair trial. And so some people look at it as bad, but I think of it as something where the court's really trying to do the fair thing, to be an actual judicial instrument rather than a rubber stamp for the prosecutor.
Excellent, very good. Well, I mean, I have a lot more questions, but we're going to have to arrange to continue this conversation because our show time's running up. But I wanted to tell the audience that they can easily get more information about the International Criminal Court by searching on the internet. And probably if you put in Sean Butler's name, you'll find out about his local organization called the International Criminal Court Alliance, which is a support group for the International Criminal Court. And it's always good to get active on these affairs. So thank you very much for watching. Try to catch us on our next show. And I just want to remind you to do one thing. Go out and help somebody.